I think we will pick up on marine scientific research in our third presentation, but for now, let me invite Professor MOSSOP to share her presentation on dispute settlement. Professor MOSSOP, please.
Thank you very much, Ambassador Lee. And can I start by just checking that my slides are available to view? Okay, I think they are. So today I first want to thank the organisers for inviting me to participate in this excellent conference, and I'm very sad that I'm not able to be with you in person. The topic of my talk today is about dispute settlement in relation to areas beyond national jurisdiction. The motivation for my consideration of this topic has been my involvement as an observer on the New Zealand delegation. And of course, I note that my comments today do not represent the New Zealand government. The dispute settlement provisions in that treaty are still to be finalised, and as Ambassador Lee mentioned, within 24 hours ago, we've been talking about them in informal discussions. So while thinking about the role of Part 15 of the Law of the Sea Convention in the future Bbnj agreement, I decided to take a step back and consider the sorts of norms and obligations that might apply in areas beyond national jurisdiction. And my conclusion is that traditional bilateral dispute settlement is not always helpful in dealing with environmental obligations owed to all states, especially when harm occurs in areas beyond national jurisdiction. So in the next 20 minutes, I will provide a brief introduction to the Bbnj treaty negotiations for those of you who are unfamiliar with the process. I will then explain why it can be very difficult to use traditional bilateral dispute settlement to resolve the violation of erga omnes norms, especially when no state is specifically harmed. In light of these difficulties, I will then mention two options that could be included in the Bbnj treaty that will help to minimise the risk that harm to areas beyond national jurisdiction will go unaddressed. I should also mention that this presentation is based on a chapter soon to be published in a book on areas beyond national jurisdiction with Brill, and I'm very happy to provide copies of the chapter to anyone who may be interested. So Ambassador Lee has already given us a bit of an overview, and we know that states are currently in the process of negotiating for a treaty. The authorisation came from the UN General Assembly at the end of 2017, and the General Assembly authorised 4 meetings of an intergovernmental conference for the negotiation of the new treaty. It should be noted that this did not come out of nowhere. Since 2006, the international community has been discussing the issues in a series of ad hoc informal working groups and also a preparatory conference. So there's a long history to these negotiations. And of course, we have one of the last of the 4 meetings still to be held, and that was originally supposed to happen in March last year, but of course has been postponed due to COVID. Now, my final point on that slide is that, that the provisions for dispute settlement have received little attention so far, and when I wrote these slides, that was very true. In IGC3, I think we only had about an hour to discuss dispute settlement. But of course, within 24 hours, we've just had this meeting chaired by Ambassador Lee, which has been very helpful in bringing out more of states' positions on the dispute settlement process. So disputes in international law are typically bilateral, involving an injured state seeking redress against a state it alleges has violated international law. Such disputes can arise out of activities in any place, including on the high seas. For example, a complaint that one state has interfered with another state's rights in relation to its flagged vessels would essentially be a bilateral dispute, no matter where the interference occurred. In such cases, the injured state has standing before international tribunals to bring a claim for reparations, provided the tribunal has jurisdiction. Of course, many important provisions in the Law of the Sea Convention are for the protection of the marine environment. In some cases, harm to the environment will involve harm to the interests of another state. In these circumstances, again, the bilateral model of dispute settlement is appropriate for resolving the dispute. However, it is entirely possible, and it's increasingly likely with the negotiation of the Bbnj treaty, that harm can be done to the marine environment in violation of international obligations, but the harm occurs to areas beyond national jurisdiction. In this case, harm to an area in which all states have an interest is in effect a harm that is suffered by all states. Alternatively, the harm may involve the violation of treaty or general international law norms owed to a group of states, and it may or may not result in physical harm to commons areas. Now, those sorts of obligations that are owed to all states are known as erga omnes norms, and I'm going to focus a little bit on that idea in the next few slides. So, first of all, identifying which norms are erga omnes can be difficult, and some commentators have suggested that all obligations intended to protect the global environment are owed erga omnes to all states. The respected academic James Harrison has argued that most of the rules in the Law of the Sea Convention, but particularly those aimed at protecting the environment, are erga omnes norms. In the advisory opinion issued by the Seabed Disputes Chamber of ICLS, the Chamber described the obligations relating to the preservation of the environment of the high seas and the area as erga omnes in character. So the general view is that a non-injured state can bring a traditional dispute against a state that has violated an erga omnes norm. And this is supported by Article 48 of the ILC draft articles on state responsibility. States have been successful in the ICJ in bringing cases for violation of prohibitions against torture or genocide on the basis of erga omnes norms. And in the whaling case, the ICJ didn't question its right to hear the case and appeared to treat the application again as an erga omnes norm to be protected. However, it is extremely rare for these sorts of activities to arrive, and it's rare for states to act on behalf of the international communities unless the interests at stake are seen as crucial to that state. Indeed, under Part 15, no state has successfully brought a case against another state where they haven't been injured and on the basis of erga omnes. Sorry. So traditional bilateral dispute settlement in international law is less than ideal for enforcing erga omnes environmental norms for a number of reasons. First, even if the legal obligation at issue is owed erga omnes and a state may have standing to bring a dispute, it is still necessary to establish that the court or tribunal has jurisdiction over the dispute, which is not always easy to do in some cases. In addition, harm caused to commons areas rather than areas under national jurisdiction provide less incentive for states to bring an expensive and politically sensitive case. Also, disputes involving environmental problems are complex and polycentric, frequently involving a variety of treaty and customary norms, making them difficult to resolve in an international court or tribunal. The difficulty of establishing a link between the harm suffered and a breach of a particular state's obligations can also be problematic. So even if you get past all of that, and even if a state does bring a case to enforce a norm owed to the international community, the process may not allow for all interested states to participate and will bind only the parties to the dispute. Although New Zealand applied and was given permission to intervene in the whaling case, Japan opposed the intervention, which demonstrates that parties to disputes may not appreciate third states becoming involved, even with erga omnes norms. It has been noted that although the ICJ and ICLS have provisions in their statutes for interventions from other states, no such provision is made in the case of arbitration under the Law of the Sea Convention. However, when a dispute involves the interpretation of a common treaty provision, or indeed an interest held by the international community as a whole, the potential exclusion of other interested states from the dispute is a matter for concern. In light of the drawbacks I've mentioned, the question then arises, is a simple importation of Part 15 of UNCLOS into the Bbnj Treaty sufficient? Now, the Bbnj Treaty will impose a variety of obligations on states, some of which will involve measures for the conservation and sustainable use of biodiversity, including obligations relating to the marine environment in areas beyond national jurisdiction. Other obligations will relate to questions like the utilisation of marine genetic resources and the transfer of technology and capacity building. Although some aspects of the treaty will create bilateral obligations owed between particular states, many of the obligations will be owed to the international community as a whole. Now, the draft provisions in the draft text follow a similar format to some articles in the UN Fish Stocks Agreement dispute settlement process. The formula of applying Part 15 mutatis mutandis to issues of interpretation of the Bbnj Treaty is the same as in Article 30, Paragraph 1 of the Fish Stocks Agreement, although the draft provisions in Bbnj are less extensive overall than the UN Fish Stock articles on dispute settlement. Whether it's sufficient to simply follow the UN Fish Stocks approach is questionable. Indeed, the application of Part 15 mutatis mutandis may be very difficult in a treaty that will relate to legal instruments well beyond the law of the sea, including intellectual property and international environmental law. I mentioned on my slide the issue of parallel dispute settlement clauses. I'm happy to come back to this, but in the interest of time, I'm going to move to my next slide. So in this part of my presentation, I want to look at two options that have been raised during the discussions about dispute settlement in the Bbnj process. The first is the option for the Conference of the Parties to request advisory opinions from ICLS on matters relating to the interpretation and implementation of the Bbnj Treaty. In the recent informal discussions, a wide range of states have expressed support for the inclusion of this option. So advisory opinions have two primary advantages over traditional dispute settlement. First, the conduct of an advisory opinion allows for input from a wide range of participants, including states and potentially intergovernmental organisations and possibly even NGOs, and we saw that in the two ICLS advisory opinions. In contrast, there is no provision for other states to intervene or express their view if Annex 7 arbitral tribunals are formed to resolve an erga omnes dispute. Second, the two prior advisory opinions issued by ICLS have been recognised for contributing to the interpretation of international law, despite the fact that it has a non-binding character. However, advisory opinions can be controversial. Some have argued that advisory opinions have been used in the past to substitute for contentious cases. It's not surprising, therefore, to learn recently that the UK, Israel, China, and the US are not in favour of the use of advisory opinions in the Bbnj Treaty. Because of their experience, it may be useful to include a clarification that advisory opinions cannot be used to resolve contentious cases. There is also a potential legitimacy issue that was raised by China in the discussions and is discussed in my paper. And this is the fact that UNCLOS does not empower the tribunal to deliver general advisory opinions apart from the specific context of the area. However, a number of states raised this issue in the recent advisory opinion on RFMOs, and the tribunal found that it could exercise jurisdiction. So it may be that we have a simple fait accompli in the case of jurisdiction. Another theme that came through the discussions last night was the fact that many saw dispute settlement as part of a broader spectrum that ranges from compliance through to enforcement. And this reflects a growing confidence in environmental regimes with compliance, or often called non-compliance procedures. Because of the fact that dispute settlement is not typically used in environmental contexts, Many multilateral environmental agreements now have compliance mechanisms, and some of the features of those mechanisms are listed on the slide. The primary objective behind this approach is to encourage states to comply with their treaty obligations, and in the event of non-compliance, to provide a softer system to address non-compliance than that afforded by traditional dispute settlement procedures. Thus, these procedures can be considered to work alongside and complement traditional dispute settlement processes rather than replace them. It's been observed that in the context of environmental obligations, it is preferable to seek to prevent breaches and harm rather than attempt to invoke state responsibility to cure a harm resulting from a breach. And this falls squarely within much of the mission of the Bbnj Treaty. These procedures are also likely to encourage just outcomes to the extent that the process provides support to states that are struggling to implement their obligations under the treaty due to incapacity rather than willful non-compliance. And such structural issues disproportionately affect developing states and are not addressed by a coercive enforcement approach represented by traditional dispute settlement. It seems that the draft text does provide for the possibility of such compliance procedures to be established. Draft Article 53 in the draft text is entitled Implementation and Compliance. Paragraph 3 has bracketed text that provides that the Conference of the Parties, and I think the intention at a later date, is to consider and adopt cooperative procedures to promote compliance with the provisions of this agreement and to address cases of non-compliance. And this wording is entirely consistent with the establishment of some form of non-compliance procedure. So, is a non-compliance procedure appropriate? It seems hard to argue that it's not. The key goal of the treaty is the conservation and sustainable use of marine biodiversity, and hence has strong environmental aspirations. And as I've already covered, environmental disputes are not always easily suited for traditional forms of dispute settlement. And this is particularly acute when addressing obligations owed in relation to areas beyond national jurisdiction, when the likelihood of a specially affected state turning up to bring the case is much lower. Leaving issues to be resolved through enforcement of erga omnes norms through dispute settlement procedures seems to leave an obvious gap in the potential opportunities to encourage compliance with the treaty. In addition, using compliance processes in the Bbnj Treaty is also consistent with the focus on capacity building and the transfer of marine technology in the package deal. Developing countries have strongly emphasised that their ability to implement their obligations under the new treaty will depend on the availability of financial and technical assistance. If the LB does establish a capacity building mechanism, then it could be used to facilitate access to financial or technical assistance for those states that may lack capacity. And it should also be acknowledged that not all of the obligations in the treaty may be appropriate for resolution by a compliance process. There might include obligations that relate to utilisation of NGRs, for example. And so it may be that such a process will need to exclude some articles or sections of the instrument. So in conclusion, the CBED advisory opinion noted that obligations relating to the protection of the environment and the area are erga omnes in nature. In part, this reflects the common heritage of mankind that applies to the area, but also the fact that the high seas are subject to no sovereignty claims. It is in the interest of all of the international community that states observe their legal obligations not only to each other, but in respect of the common good. While traditional dispute settlement is important and should be part of the package, it's primarily useful for bilateral disputes and less successful in relation to enforcing common interests. So my hope is that the treaty will contain other mechanisms to encourage compliance by all states. And I see the advisory opinion and compliance procedures as a key part of this structure. Thank you very much.
Thank you very much for that, Joanna. And indeed, I think we do see most recently in the Paris Agreement an example of how a non-compliance procedure can work interacting with dispute settlement.